Try that again.
We have launched.
All right, so...
It worked that time.
This did much better that time. All right, Planet Green Trees, everybody. Officially episode 184. We're calling it Federalized. Today's January 30th, 2014. The call number is 1-347-326-9626. Visit us at www.planetgreentrees.com. I'm your host, Michael Komorn, Komorn Law, alongside me to bring you the most outstanding and informative and entertaining medical cannabis and cannabis reform blog talk radio show, Chad, from the Birmingham Compassion Club.
Good evening. It's nice to be here.
The other major contributors to the show, all that we were expecting tonight but have not arrived, the one and only Compassion Chronicles editor-in-chief, Rick Thompson. Hello, everybody. Just kidding. And, of course, Jamie Lowell from Third Coast Compassion Center.
Hello. Hello.
Tonight, we are going to be discussing, are the federal courts beginning to recognize the Department of Justice's policy concerning not targeting cannabis activity allowed under state law? Planet Green Trees host, attorney Michael Komorn, I was recently able to avoid a mandatory minimum and prison sentence time for clients, and some of the arguments actually came back to some of the things that were going on in Michigan law, in a new federal policy in federal court. Also, newly formed Cannabis Stakeholders Group hires major lobbying firm to help with medical marijuana issues in the state legislature, and we're going to hear and talk about that. Joining us tonight will be Eric Gunnels, trustee for the Thetford Township. That's just it. Trustee for Thetford Township. Text him at 810-875. All right, just kidding. Of course, he's currently involved with and been nominated as the chairman of the steering committee for the Cannabis Stakeholders Group. He's going to be discussing the formation of this new organization and what exactly are their plans moving forward, and the hiring of the powerful lobby firm GCSI, and find out exactly what their strategy is, and as they try to rally the community together. Taking calls on that. Want to hear everybody's thoughts. Also, discussions on the. I'm going to be discussing, but we have a special guest, a good friend of mine, someone I like to call the Professor, John Targowski, who is finishing federal cases in Michigan as he prepares to move to Los Angeles to practice in federal court in California. He's going to give his perspective on the blurred lines of the federal and state medical cannabis and marijuana issues. Also, my two clients, one of my clients and his brother, are going to be calling in to discuss the experience of being charged federally in a case involving 600 cannabis plants. We're going to discuss the experience and what can only be described as escaping the jaws of death. I want to give a couple of shout-outs. I'm going to rant about this in a couple minutes, but huge thanks, really, today, if any of you are listening or if you happen to catch the archive, but to really what were some of the most heroic and inspiring individuals that I've ever met, an opportunity to speak with, patients, medical cannabis patients, who drove literally collectively thousands of miles to participate in the defense of cannabis oil, and in the case of People versus John Roberts. I'm going to rant a little bit about that, but I can't tell you how, really what a inspiring act it was to show up. I know the last person that testified drove all the way from Traverse City. I got off the phone with her last night at 10 o'clock. She had to go to bed because she's getting up at 4 o'clock to drive to court. And just the commitment to be involved is and put yourself out there independent of the experiences that you were having as a sick person. And that goes to all the patients. And some of them are going to come back, which is even more amazing. As always, to my good friends, Pam and Dewey, I have to tell you that your absence today because your sickness was missed. And while Chad has a tremendous amount of value in the office, he is not Dewey behind the wheel. I'll tell you that. Several errors and lateness.
Not a professional.
But I do want to thank Chad because one of the challenges of getting this all together and managing 9, 10, 11 patients who are going to test witnesses in any case and getting the medical records and with the very organized way in which our client was assisting us. I'm making quotation marks with my hands. Chad had to step up and really did a phenomenal job. So, Chad, thank you. You really helped today. Independent of whatever happens, I can't tell you how difficult it is, although we should have everything copied before we left today. And a reminder on the exhibit stickies.
New formats.
Also, our good friends over at the Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. I want to thank all the moderators and administrators who volunteer their time to assist in the safe, comfortable environment involving the conversation of medical cannabis. Komorn Law, PLC, 1-800-656-3557. The Marijuana Rancher, the one and only, 313-422-5281. If you're interested in a cultural center of cannabis, you may want to call and set up an appointment. Chad wanted to comment on the Rancher's recent activities and set the record straight. Chad, take it away.
I've said enough, I think.
Taking the fifth? Okay. Of course, the one and only Dr. Kumar Singh of Greenlight Clinic, 248-390-0574. As I say week in and week out, and what clearly became an issue today, the significance of your certifying physician and the way in which they handle your chart, or said another way, the way the patients are able to manage their chart in compliance with the law is critical. Dr. Singh is aware of this. He's worked diligently to conform, and I would call him one of the gold standard physicians who are doing certifications. As you know from other episodes, we've addressed this issue, and we've pointed out some of the other physicians who we encourage patients to interact with, that being Dr. Robert Townsend, and I think a couple weeks ago, and of course Dr. Crocker. I would also recommend, because of just such wonderful testimony today, cooperation in the preparation of coming to court, taking time off of his busy practice to come in and stand behind and give testimony in support of his certification of one of the patients, Dr. Myers, two patients, Dr. Myers. Thank you, Dr. Myers.
Dr.
And
Paul Meyer in Saginaw.
He would be another one we're adding to the list. He, and especially for those individuals, I would say, who have not had a treating physician as of late, because he's a family practice but does multiple different types of treatment to assist you in your condition. Dr. Paul Myers of Saginaw. And that's who I want to give a shout out to. So, as I speak of the Dr. Meyer and the events today, and it's fascinating as you get ready for these Section 8 hearings, because there's such a limited view on the way in which the Medical Marijuana Act has been interpreted. It still remains. It remains in the courts, and the expansiveness by which Section 8, the tools of defending yourself, the way it's been interpreted in the court, and it is merely a silver lining in what has been oftentimes described as a failed implementation of the Act, because, number one, the strict compliance with Section 4 oftentimes is not a fair debate. That the workability of is sometimes challenged because of just the way in which caregivers or patients need to interact with the cannabis to get it prepared and ready for ingestion. And weight issues and continuous supply issues are always going to be challenged when it's your behavior as a medical cannabis patient is scrutinized under Section 4. Also, one of the topics which is often not really addressed as to why and the logic, and I'm going to toss this out to the professor and see if he's got an opinion about this, but we often talk about, and the professor, John Targowski, also will be the first one to tell you, as I talk about every week, that the way in which the Michigan Medical Marijuana has acted with the existing prohibitions of marijuana was the issue in terms of how the Supreme Court was going to interpret and implement. And they had to start at certain points in order to begin the analysis of how the Act was going to work. Some may have thought that the impact of the Michigan Medical Marijuana Act was going to completely consume the prohibitions of the use of marijuana. In other words, it was going to be bigger and stronger, more powerful than the Public Health Code, the statutory scheme which prohibits the use of marijuana. Or was it going to be something equal to it where they were going to play against one each other, or was it going to be something else? And unfortunately, the interpretation of the Supreme Court has been that it is something else. It is not bigger than, it doesn't encompass, it's merely become a small minutia of protections for very limited, unambiguous activity, unambiguous defined by the law enforcement community, to which they have not offered a unambiguous response as to how this behavior can be done in a way that would be satisfactory. And it's challenging, and the real question I'm going to ask, and Chad remind me, is how do we get to the place? How do we get to that interpretation? Why do we start here? Why do we start in the position of the Michigan Medical Marijuana Act did not legalize marijuana? Why not? Do you think the voters of
still wanted it treated as a Schedule I controlled substance?
Arguably not, when the proclamations and preamble of the Act specifically assert that marijuana should not be considered as a Schedule I drug because it does in fact have medicinal value. But I say all those things because in light of the events today, and I want to just briefly go into some of the details of the case, there are different ways to defend a medical marijuana case when you're asserting an affirmative defense, and Section 4 is not Section 8. And you have to address specifically the three prongs of Section 8. The first one seemingly is the most difficult one to establish, but is the issue of the physician and the physician's statement and the physician's statement as to the bona fide relationship or testimony as to the bona fide relationship. And now, of course, the bona fide doctor-patient relationship has been defined by the amendments of 2013, and they didn't do it just for the purposes of adding some words to the document. They did it to give some fodder to prosecutors and some words and elements to say have not been established. So when I spend what could be described as way too much time talking about the bona fide doctor-patient relationship, I'm not saying it for my health. I'm saying that if you have that and you bring that to court, we're going to win in a much easier manner. Today's experience, I would say, did not necessarily involve that, because I said Dr. Meyer had more than a bona fide relationship, as his testimony reflected with my client and his relationship. But what was fascinating to me in going into this was the actual patients who testified. It was fascinating to me. It was preparation for a section that I never had before. I want to spend a minute to talk about the witnesses who were willing to come forward and testify. These are people who remain nameless but who had tremendous courage. They are individuals who have been diagnosed with life-ending diseases. There was 3 patients that testified that after their last bout of radiation, they said, that's all we can do, that there's not really anything we can do, but you should probably get a will. You should probably look into making nice to the rest of your family. You should probably think about enjoying yourself for the next years, and we can't help you anymore. So I don't think that I've had a case yet where I've spoken with 3 individuals who were looking for a miracle. They were looking for a miracle because there was nothing else, and they wanted to do everything in their power to stay alive. Now, I think that the Michigan Medical Marijuana Act extends beyond individuals that I'm speaking of, but without question, the intent of the voters was to be able to protect these individuals. In fact, one of the patients even testified that I didn't get a card. I'd been diagnosed. I'd been given X amount of periods to live, and I was, interacting with people, and they were providing me cannabis, and just testifying about using cannabis. I mean, she'd been diagnosed with a cancer that was going to purportedly end her life within a short period of time. The not remission, but the ending of the chemo and giving her a pass for a period of time ended, and cancer reemerged, and chemo, and then reemerged again. It was one of those situations where, what else, can you blame someone for not caring to get their card or have their doctor follow up with them on that issue? I mean, it got kind of silly. In fact, some of the questions that were being asked and the nitpicking that took place when the testimony of these individuals, patients, was so compelling. Furthermore, is a testament to my client, and really, as I went through this, I realized that there's something unique about him and his undying commitment and really compassion for wanting to help these individuals, and honestly believing in his heart that he has access to a miracle that he wants to try to provide and assist people in prolonging their life or possibly curing cancer. I will threaten this right now that we are discussing having a Does Cannabis Cure Cancer show. We're going to queue it all up. We're going to get some of the literature together. We're going to get some doctors together. We're going to everybody have their opinions and thoughts. We're going to resurrect the away for way too long friend and colleague and I want to say family, my good friend Peanut Butter Gersh Avery. We're going to get him back on hopefully and address this issue. Maybe we'll even reach out to our good friend Rick Thompson, whose name was mentioned on several occasions today during the testimony. But, I go through a certain process when I speak to the patients in their preparation of their testimony. And I say a lot of the same things over and over again, and they were all nice enough to join me in a conference call so I didn't have to do it 3 or 4 times as we were getting the case together, and I appreciate that. And they were very open with their journey. But one of the things that can't be understated is when you talk to someone who's in that position, you ask them about their condition, they say it in a very matter-of-fact way. And they talk about it in a way that, seems to be almost surreal. But I realize in talking to them, it's because the diagnosis, there's statements that are made by the physicians to them are not encouraging. And those individuals who would get caught up in that and the things that are said and the statements that are made are things that they don't want to believe because they want to remain alive. And they have choices in those moments to either believe what they're being told and get depressed, stop living, stay at home, or they overlook these diagnoses and they go out and they live. And I can't. And what I'm trying to say is that they are not people that speak with the desire to get sympathy. They're not looking to make people cry. Oh, look at me, poor me. That is not the way that they're living, and it is just an amazing journey that they're going through and the way that they've chosen to address it. And it to me defines heroic and much, much more. And the experience of this entire 5 or 6 years had a certain pinnacle today as I listened and watched and heard people talk about like experiences that at very young ages that most people don't go through. And in the back of my mind, I couldn't help but thinking, for the love of God, why the hell can't they use their medical cannabis? And why the hell does the government care how they're using it? And one of the patients, who happened to be a naval police officer, never really used marijuana, at a very young age was diagnosed with a disease that they said they'd never seen in the United States before. And the experience that she went through and the courage that she developed in coming to court, and it was a very challenging physical. And it is it's just a fascinating journey, and you understand why individuals are in such need. And this whole experience as a medical marijuana lawyer is probably very close to a very sick community who is challenged by the current medical system and the way that medicines are being distributed and the cost and expense of it. And really, at the end of the day, it's about, to me, these individuals who have ran out of options and are declaring their God-given right to choose what medications they want to use to treat their conditions. And their choice in these instances is the hope and prayer that Rick Thompson oil, or what's common as honey oil, or cannabis oil, it's been around for 5,000 years, and arguably was the oil that mentioned in the Bible, some want to believe. It's oil that has been used in medicines, and if you looked across any pharmacy or the equivalent of pharmacy in the late 1800s, early 1900s, or in the physician bags that did house calls, when doctors used to do house calls and have their house call bag with them, inside of it would be, and on those shelves would be, cannabis oil of some kind. And the idea that it does not work for individuals or somehow needs to be scrutinized by traditional medical institutions, and the expectation that physicians who are oncologists, or I shouldn't even say it, because one or two of the patients, at least, they're oncologists, had recommended cannabis. But the idea that some of these institutions are not, by policy, able to recommend medical cannabis, but have no problem turning their head and encouraging their patients to use it without actually stating it or writing it, and that for some reason should be a reason why somebody can't assert a medical marijuana defense, or the reason that the caregiver of the patient didn't have a letter from the doctor, somehow putting the onus on the physician in the certifying process of having some duty or responsibility to know the exact amounts of how much a patient should be ingesting. We had a discussion today, and I think it's an important point. I'm going to move on, and we're going to take a break in a second. But one of the not-so-discussed topics beyond prong one, the bona fide doctor-patient relationship, is who is it that shall declare what a reasonable amount is that's necessary? And that Hartwick decision, which sometimes has been discussed of who it is, seems to put some of this burden on the doctor. And at the same time they do this with what can only be described as negligence. They use the word prescription for the recommendation, completely discrediting, I think, the reasoning and logic of the opinion. But this issue came up a little bit today, and while I don't think it's been declared specifically, there's two important points that I think need to be made. One is that the federal courts have spoken on this. There's a case, Conant v. Walters, from 1996, which involved the U.S. Attorney or the Department of Justice bringing injunctions against the physicians that were making recommendations in California. And the case went to the Federal Court of Appeals, by which they ruled that this act by the physicians is not a prescription. They are not engaging with the prescribing of a Schedule I drug. What they are doing is they are exercising a very important constitutional right, which is a First Amendment right, a right to speak and discuss and engage in and recommend to a sick person that they are involved with treating what the best possible remedy may be. In other words, the reasoning of the Ninth Circuit Court of Appeals was that under no circumstances should a sick patient not be given multiple options, some of which may or may not be legal, but they should be discussed. I use the analogy sometimes, even if, going outside the office and banging your head against the wall may be in a study somewhere in Switzerland that cures headaches, the doctor should be able to discuss it with the patient as a possible recommended way to treat their issue. But under no circumstances should the doctor go out into the hallway with the patient and assist them in banging their head against the wall. And the idea that this recommendation somehow puts this burden or onus on the doctor to do that is absurd. In other words, the Federal Ninth Circuit has said it is a First Amendment right of speaking and recommending what may be helpful to treat your serious or debilitating condition. I remember a circumstance that I had in a case in Livingston County where a physician had gotten on the stand and discussed his recommendation process. And when I was asking him questions on direct exam, I'd throw him softball and he'd hit it over out of the park. And the prosecutor, cross-examination, got up and said, Doctor, if I understand what you're doing here, it seems to me that you are assisting people in getting a Schedule I drug. Assisting people getting a Schedule I drug, and seem to want to lure him into some kind of federal issue with his DEA license and his license to prescribe medications. And I say all that because it's absurd. And the trend potentially in these courts is to put this tremendous burden on the doctors to have more knowledge or understanding the amount that's being dosed, the quality, how frequently it's used. I mean, these questions are being posed to Dr. Meyer, and it was silly. I mean, he answered all the questions in the absolute right way, well, in the exact proper way, by saying, well, there are multiple factors that go into how much somebody should use, and it's nearly impossible to say. I mean, the varieties and variables that go into the plant itself are too wide to even suggest an amount. In other words, you could have an ounce of marijuana, bud and flower that, 10% THC for someone who has a lot of pain, and they may need to smoke if they're smoking 4 ounces a week. But at the same time, if they've got a strain of an ounce that's 20% THC or 30% THC or 15% THC and 15% CBD, is that even a possibility? I don't know. But whatever the case may be, it's going to have a different effect. So to say how much a patient should use when the complexity of the possible factors that would line up to direct that are infinite, something that nobody could wrap their brain around, no doctor. Doctors don't even really fully understand the minutia integration of the substances that they're prescribing. They know that 10 what is the measurement for Vicodin? Milligrams of Vicodin is exactly that. And if they need to look it up in the physician desk reference, they could find it. And they know that the pharmaceutical companies have suggested, different pain levels. So there's some testing that's been done that's providing as close to absolutes as possible. But those are chemicals. They're not natural. And it's easier to do with synthetic components. The other thing that I think is also an important point is the purpose and intent of the Michigan medical marijuana. What does it say? Is there anything that we can draw upon from it that would suggest that there's an answer as to what is the reasonable amount and who should be declaring it? And I point to Section 6 of the Act. It's parent 7, I believe, going by memory, but it's in there. And it's the section that refers to the patients who are not adults and the requirements of having 2 doctor recommendations and the requirements that the parent or legal guardian be the caregiver for that minor. And specifically, as enumerated within that section, that caregiver, parent, or guardian shall be the individual who acquires on behalf of the minor and also determines frequency of use and dosing. Now, why is that important? I think that it's extremely important because in light of Conan v. Walters, which is a First Amendment right only, and don't go too far, doctor, because you should not be engaged in the acquisition of a Schedule I drug, according to the federal government. You've got huge liabilities. You've got to be careful about walking over that line. But at the same time, the Act tells us that if the concerns, as we all have for our children, if the concerns were so great as to whom was going to be deciding the amount of cannabis that should be ingested and the frequency of use, they would have put that burden on the doctor. Instead, only because the patient to whom we're speaking of is a minor, the only place in law enumerate who will be the person that determines that. And when given the opportunity to say physician shall determine frequency of use and dosing, instead they choose the caregiver. So what does that mean for everybody else?
I'm going to
argue that it's the patient or the patient's caregiver, and certainly not the doctor. In other words, if they could, if the real intent of the law was to declare that the doctor had to determine the amount, they would have said it right there because, as we all know, if you're going to find something to be sympathetic about and direct attention, a reason to have exceptions, it's to protect the children.
Parents don't determine their dosage on their children's other drugs.
That's right.
They're only doing it because the child is incapable of dosing themselves as it's meant to be by the law.
That's right. And there would be nowhere else to turn. And to put a doctor into that maze.
Put an unqualified person.
That's right. I mean, I will say that Dr. Meyer probably, if anyone, after hearing him testify, could have given a reasonable opinion about it because he's knowledgeable, he knows and is aware of the Cannabis Cancer Project and the work that they've done, and he described going to 5 or 6 different seminars.
He certainly can say more or less.
But what he gave was the answer, which is that no, you can't because there's too many variables. Something interesting that he said also is because his background, he does have a background, and one of the parts of his practice was drug addiction. He said, I've yet to see a case where somebody gets their medical marijuana and use it as it all in one day. That's something you just don't see. Just the opposite for people with, you'll see somebody take all their prescription pills or increase their beyond their recommended dosage because of the pure nature of the drugs themselves. All right, the producer's here. Oh, I didn't mention he's here, and he's telling me to move on, but we will do that. And that's the rant for right now. We're going to take a break. I see a lot of numbers calling in, and we're going to hear from all of you and get your thoughts on this. You're listening to Planet Green Trees. The call number is 1-347-326-9626. We'll be right back.